thing we want to state is that there was no plea agreement in this case. There's been some distortion about that somehow Father Deland entered into a plea bargain. There wasn't. He pled no contest to all of the original charges, which were 6 felonies and 1 misdemeanor in this matter. The reason he pled no contest is that there is a pending civil lawsuit filed in the Saginaw County Circuit Court. And because of that suit, he doesn't have to admit his guilt. What no contest means is he's not contesting the prosecutor's evidence. He'll be sentenced like any other person who pleads guilty. But now that he's withdrawn his pleas of no contest, we're ready to go to trial just like we were in September. Nothing has changed.
So, because I've been to the court cases but not been doing obviously some of the follow-up work. So the OV4 and OV10, why were those scored at 0?
We cannot discuss the OVs just because the pleas have now been withdrawn. So we can't comment on punishment or details about the case because now the presumption of innocence has been restored. So ethically we can't comment on the sentencing guidelines. And I apologize for that, but kind of ties our hands now that we're actually going to trial. That implicates punishment and we can't really go into it.
So can you explain though how, obviously I don't do the scoring guideline thing, how, what's it, a fine line, but is there some leeway as to how you can score things, like in general terms, like how, you know, one person, you might look at it as being a 5 and you might look at it as being a 0. Like, can you talk about that, how there's some discussion about it?
Well, just to set the record clear, the 1 OV was not a 0. It was later scored correctly a 10.
Okay.
Okay. I think what happened was...
Which one? I don't know the difference between, okay.
Right. They were scored correctly. What happened was there was a misstatement in the courtroom about the scoring, and it was later corrected. That got lost in the shuffle of all the reporting. That wasn't true at all. So they were scored from our perspective correctly. When you go into a Cobb's hearing with the judge, everybody's got a different interpretation of the guidelines. The prosecutor, the defense, and the judge, and I'll let Melissa explain this better like you just did before about how when you first go in there, it's a preliminary. It's much like when you first go in for the first Cobb's hearing, it's like going to the doctor and you get a physical exam. But you don't know the true story until your lab or blood work comes back. That's the final analysis. We weren't at that point yet.
Okay.
So a Cobb's, I hate calling it an agreement. It is a form of sentence bargaining, but it's more of an evaluation, a preliminary evaluation. So basically the attorneys score out, just do a rough sketch of the guidelines, how they interpret them, and the court at that point doesn't really do any scoring until they're able to get the pre-sentence report. So it's more of a preliminary evaluation kind of based on the facts that we have right now here in front of us. Not having a trial, not having a lot of things, you know, other facts come out. Right now, right in front of us, this is what we've got, this is what our scores are based on. So when this evaluation is given, it is based on that preliminary assessment of the guidelines. So that's why if a judge ultimately gets some more information or looks at other aspects of the case, that's why the defendant has an automatic right to withdraw the plea if the judge can't go along with what he initially assessed, looking at the case as a whole.
And so when we met with the judge again...
When did you meet with him, on Friday?
No, before that.
Okay, okay.
Right. Okay. And we can't discuss what goes on back in chambers, that's confidential, but he alluded that he might be seeking a higher punishment. That happens all the time. Sometimes they might seek a lower, they might seek a higher. He's the one who gets the final call on that. And Judge Jackson did the right thing. He did the ethical thing when he determined that he might be doing something different than both sides were talking about. The ethical thing to do was to allow the defendant to withdraw his pleas. And so we did that. So we're just back to getting ready for trial. Nothing has changed.
So, you still stand by then what you said in the press conference, that there was no deal?
There was none. There was no deal on the charges or the sentence. There was no recommendation. There was no agreement. We just scored the guidelines. We discussed it. We reevaluated it. was like I said, initial visit to a doctor's office is what it was. So many people, I think, are confused by the fact that since he pled, there had to be a plea bargain. But there wasn't any. This was one of those rare instances where he pled to all of the original charges. You don't see that all the time, but in this case, it happened.
What do you have to do now to get ready then? I mean, obviously, I know you said you were ready before. I mean, did things change? Does this change the way you handle things?
It doesn't change a thing. We've had a very thorough and complete preliminary examination. We got ready for trial, for the September trial dates. Now we're just in a holding pattern. The court's kind of clogged right now, so these cases will go to trial in January.
At the earliest.
At the earliest.
Oh,
yeah.
there's not a date?
It's not at this point, no, not a date certain.
Not date certain, but we've been advised most likely January.
You know, some people obviously were upset when this was announced that he wasn't going to go to prison. Will the scoring guidelines change now? Could that be a possibility, or is that still, I mean, if convicted, is that something that this possible sentence could change for him?
Absolutely, absolutely, because the offense variables, and just generally speaking, the offense variables are often what attorneys bicker about at sentencing in terms of, you know, each person's interpretation of the facts. So when more facts come out at trial, and when the judge hears all the facts, that certainly could change how things are assessed at that point.
Now, I probably have this written down somewhere, but what was like the maximum and minimum for the charges that he faces?
The maximum is set by statute, and that is for the criminal sexual conduct is 15 years. Okay. That's set by statute.
Yeah, yes. Yeah. That's what I was talking about.
And then the minimum is where the guidelines come in, and again, I'm not gonna really get into that just because, yes, the maximum is 15 for that, up to 15, yep.
Guidelines are all about the minimum.
Okay.
Yes.
They're all about the minimum.
Obviously, you have 3 victims here who have been involved in this now for a little while. When's the last time you talked to them, and how did they feel about before this was kind of getting close to being done, and now there's a longer road in front of them?
We've talked to them. We've had one of them here to the office. The police, who are their immediate contact, that have developed a very good relationship with them, they've talked with them. They're ready to go to trial, just like we are. Nothing has changed with them.
Anything else that you would like to say?
Nope, we're good, just ready to go.
A quick question.
Sure.
Yeah.
So what he pled to, he was facing 12 to 24 months. Those were the guidelines that originally.
Those were the rough preliminary estimates.
After the Cobb's hearing.
Yes.
Now that he withdrew his plea, and he can go to trial, you saying he can face up to 15 years now?
Well, that's always the maximum.
Okay.
That's
So
maximum.
the offense variables could be scored differently, but at this point, we really can't comment on what the penalty is going to be because now we've got a potential future jury pool.
Without commenting about what the penalty should be, what do you think is appropriate?
I can't. Nope.
Yep.
Not ethically. I apologize. I would like to be able to.
We apologize for doing that.
No, I don't apologize. I mean,
Not to be evasive, but we just.
You can't answer it.
The second degree criminal sexual conduct carries 15, and by law, it can be no higher than 2/3.
Correct.
So the highest the minimum can be under the law is 10 years. So the most he could face is 10 to 15. The guidelines are all about the minimum, okay? And the minimum is where you score the variables, the prior record and the offense variables of the instant case in front of you. That's what the defendant cares about. Any defendant cares about is what that minimum is going to be.
So he just went from facing a maximum of preliminarily a maximum of 24 to now if this thing goes to trial, it's 15 years.
No, 15
No.
is the maximum.
That's that's something he can face. That's
Nope.
a max.
That's the maximum on the statute. But how many years ago was it where we had the 10-year or the 2/3 rule?
Oh,
Indeterminate sentencing.
The Tanner
I
rule.
guess
The
I'm
Tanner
saying,
rules from years
if he
ago.
get convicted, what is the absolute most time he can get under law?
And that's something that would be a matter of calculating the minimum. So 15 does not change. Didn't change when he pled, doesn't change now. 15 is always going to be 15 because that's set by statute. So when we calculate a minimum for the sentencing guidelines, there is a low end of that minimum and there is a high end of that minimum. So when you're talking 24, that was a high end of that minimum as it was calculated at that time. 15 years does not change.
So, and that's what I'm asking.
Right.
Can it go over 15 years?
No, it cannot.
So it stops at 15?
Right.
Okay.
And that's the maximum.
When was the Cobb's hearing?
September 4th or something?
Wasn't that when we were in court, or no? No.
It was earlier in September, like the 4th, when they came with the guidelines and all that.
Cobb's would have been before the last time we saw you at the police department, correct?
Yeah. Yes, correct.
Yes.
Okay.
Correct.
So
Yes.
then, have there been any hearings, like public hearings since then, or has it all been what the behind closed door with the judge thing?
Other than putting the plea on the record and the
That's
withdrawal of the pleas.
Okay.
Those are the
That's
only
the
two.
only, that's the only 2 times we've been in court,
Okay.
officially on the record.
Okay.
Yeah.
And you're gonna have to excuse us. We're trying to kind of keep up with all this, with how highly publicized this is, but honestly, this is something that is not an uncommon occurrence in terms of the, you know, the preliminary assessment, the rough estimate of the guidelines, and a defendant having the absolute right to withdraw his plea if the judge can't go along with it. So it's something that's kind of really,
It's not uncommon
To us.
for this situation.
When
so,
were you made aware that he was going to withdraw his plea?
right before he did.
Oh, okay.
Right before he did.
Was there like a hearing set up at that point, or was it just something that you guys, both sides had called a meeting or something?
We didn't know until the hearing was actually scheduled that that was what was going to take place. Because obviously at that point, when it was indicated that, you know, the judge couldn't go along with what he had initially evaluated the case at. So after that, it was up to the defendant, and then we found out he was withdrawing his plea when he withdrew his plea.
Yeah. And like I say, it's not uncommon.
Yeah.
It happens. It's just that this is a highly publicized case, so it's something new, but this happens frequently, especially on serious and violent crime. That initial evaluation, the judge might change his mind. He might want to go higher, he might want to go lower. Like I said, it's like the visit to the doctor. You know, you don't know the real story until you get the lab work back.
And the last time we